concern is the statization of employment law. I say federalization, but I never said that. The commonwealthization of employment law.
Okay, so since you work on motions.
Yep. You have an amendment you'd like to offer?
I'll move that we strike the last clause that starts in addition and ends with the end of that sentence.
So you would strike on line 97 after cost period, strike the rest of the bill.
That's right.
And so then the remedy provided, it would be in addition to the penalties above, the employee can bring an action to recover the wages due, and if the court finds that they failed to pay in section A, the court shall award damages, interest, and attorney's fees, and other costs.
Yes.
Okay. All right, we have that motion to strike 97 through 99 after cost period. Do we have a second? All right, move in second. All those in favor say aye. Aye. Those opposed? All right. You know what? That was a total jerk move. I never even looked at you that whole time. You cool with that?
Yeah, I'm fine.
Good one.
Okay.
You carry ways at times.
I almost voted for it.
All right, so does that amendment change anything? Does any proponent or opponent want to speak to the bill now with the new, I mean, this is a bit of a watered down, but I'm assuming you still oppose. He's taking out the enhanced damages provision on proof of willingness.
Mr. Chairman, members of the subcommittee, it looks, as I read the bill, the beginning of subsection J talks about, in addition to any other penalty provided by this section, and without regard to any alternative administrative remedies provided by this section. So you could go through the administrative Department of Labor and Industry process, get penalized through that.
Yes.
Wages awarded through that process, and then a new cause of action in court, penalties under that, and wages provided.
Well, the wages aren't awarded under the administrative process. That is just an administrative penalty. But yes, you could be penalized and held civilly liable with a payment there.
Right, and so we would object to that.
Okay.
Can I ask a question, Mr. Palmer?
Go to Scott.
So, Mr. Palmer, if you struck the first clause of that paragraph, it just started at if an employer fails to pay wages, would that make a difference?
We can still oppose it, I'm just giving you lots more reasons why.
Well, and I think you can't do an either or, because then it's like first to the courthouse and you disincentivize Department of Labor from holding people accountable. This is one of those bills that if we heard the first meeting, we would probably spend 3 meetings on.
Yeah, sure. We can.
Doug Lethwich has moved to lay the bill on the table, moved and seconded. That's a non-debatable motion. All those in favor say aye. Aye. Those opposed?
No.
All right. Thanks for bringing it to us. I think we need to keep working on it.
All right, thank you.
Okay. All right, Lee. You just have one today?
Actually, I have two today.
Thought so. Okay. It's 2128 your other abuse that we heard before.
That's
And
correct.
you have a substitute that strikes everything except the word other abuse.
That's correct. It was actually suggested by Delta Kilburn. Who became a voting
All right, so we have the substitutes before everybody to 2128. Take a look at it. All it does is strikes that definition of other abuse and just leaves in the phrase other abuse. So it sort of clarifies what's admissible. All right, with that, I don't suppose, what was his name, Tyler?
Tyler, yeah.
Tyler's mom, they're not back.
They're not, but they're certainly very keenly interested in this, and I've been communicating with Ms. Russell all day today. She and Tyler are very concerned, obviously, about this all we talked about.
When we heard this bill the other day, we got so sort of wrapped around the axle on it, we never actually fully heard the testimony from everybody. So if you have other people who testify to the bill, and we also will hear from family law council people as well. I assume your part of the presentation is the same as it was the other day.
Yes, I think Ms. Russell and Tyler gave very compelling testimony. I will say that although they can't drive all the way 4 hours from Abingdon, Ms. Russell gives me several other examples of people she knows where this has happened. A lot of those involve someone's abusive to a girlfriend. And the heart of the bill is very simple. If you are abusive to children, if you're abusive to women, you may not be a good dad, and of course, you'll at least be able to consider that fact in determining the custody of children. And of course, at the end of the day, the court will decide along with a long list of factors. We just don't want courts to do as the court did in her case and say, oh, I can't consider this because the General Assembly has said in 9, we only look at family abuse, we don't look at non-family abuse. That's what we're trying to do.
Okay. All right, was there anybody else here to speak in favor of the bill? Anybody here to speak in opposition to the bill? Come on up.
Tyler Deal, and I'm here on behalf of the coalition. We oppose the bill and its current amended version also. Other abuses so generic, and you could have an event 20 years earlier where somebody got into a fight, and a lot of times you can be abusive between adults, and from the psychological cases I've had where I presented experts, it doesn't have a nexus to mean that it's bad for the children. There may be cases where a behavioral pattern couldn't affect that, but to just say other abuse, I don't even know what that means, first of all.
The problem is, here's the catch-22. He tried to define other abuse, and we all said, oh, defining it's causing a problem.
Well, it does, because they had stuff that said reasonable fear of apprehension of harm. Well, what does that mean? A mother pinches her child on the cheek too hard, the child's got, there's a degree. I think that factor 10, in my experience, is already uses any other factors that you can bring it in on.
All right, so
Had
let
that
me-
happen.
let
So
me-
that's our main position is A, it's covered by factor 10, and 9, the court can look at,
I don't think you were here last week
I
on this
was not.
bill, and Cheshire was here the other day. So the scenario that instigates this litigation is a situation where there is
I heard
a type of other abuse to a non-family member, but someone who in the modern world probably is a family member, just doesn't fit one of the definitions. And the court says, I'm not letting it in because 9 doesn't allow that, and because 9 is more specific than 10, I'm not gonna call it one of these catch-all things. My question for you is that a one-off decision by that judge, or is that something that you're seeing in your 40 years elsewhere?
I would say that by itself, that doesn't prove that he's bad as a parent for a child, and what's the relevance probatively?
He didn't ask that. He asked you a specific question. Do you think it is a wayward judge, or is it because you're in court every day of your life, you've been doing this 40 years, that most judges get it straight, that this is an anomaly situation?
The second,
Okay.
Okay. That's what we want to know.
Now, what you were trying to say was, in fact, he's not a wayward judge. Maybe he didn't think it was relevant to the best interest of this child.
it would be under the factor of your scenario of the mental health of the parties, which is a factor. And if the person has a tendency to be abusive, and you brought in some expert, because we do forensic evaluations or psychologicals, if there's an anger management problem, a lot of times we bring in our experts to say it's controllable or it's addressed to adult, but not children. So I'm worried that an overkill, in a sense, is trying to put a nexus of every abuse situation, making it relevant to, and as the court then, you pass the statute, the court has to look at non-relevant abuse, because it says any other abuse without limit. And so we're gonna have a lot of time on things that may be relevant, may not. But if you have the abusive spouse, like you said, and there's an anger problem, it's usually a pattern, you bring it in under the mental health of the parties, which is already a factor. That's really where it comes in, because you're worried about that conduct that would harm a child. We're talking about harm to a child, not abuse between girlfriend 10 years ago, 20 years ago, before the parties even married. This is so open-ended that I think that even within a definition, it would have been over.
Well, I mean, I think it's intentionally open-ended, not Delegate Campbell.
Well, that's why we
Hold
oppose
on,
it.
Delegate
It's
Campbell.
gonna open up a lot of time.
Hold on, Delegate Campbell.
Mr. Bill, I have a question for you. If the language after other abuse was inserted, this language is inserted, as deemed relevant by the court, would that correct a lot of your concern?
I can't speak for the whole coalition on that one. I still think that, we think that it's already covered under the 10. The position of the coalition is already covered under Factor 10. So
I understand, and I've done this law for 20 years, so I know that most judges would take into account the factors as set forth in the 10. However, would you agree with me that in Section 9, it defines the types of abuse to be considered as only family abuse and sexual abuse?
I agree.
specific type of abuse. Under this factual scenario, you have a mother who has a child previously and marries a new guy. And they're married for 6 months and he adopts that child. And then 2 months later, that mother finds out that he has previously, in his previous relationship, badly abused his children, not to mention his prior wife. And she no longer wants to be with him. And she separates from him and seeks to have a divorce, and now newly adopted dad comes after custody. Would you not think it would be good public policy for the judge to consider the prior abuse that took place in the prior relationship in making a determination as to custody?
I would certainly think so, but the issue would be, is it already covered under factor 10 or other factors? And I think it would be.
Would you agree that the judge could get it wrong under the statutory construction, that the expression of one thing is to the exclusion of all other? And you express specifically here that either that only sexual abuse and family abuse can be considered. So other types of abuse might not be.
I've had success in using factor 10, and that's the experience of our coalition. That's all I can tell you. We've had those issues, and in the limited issues that we have, that would be under factor 10 or the mental health of the party, you can bring that in. So I still think it's already under the scope of what we have. That's the position of the coalition. Because what you're going to have then is, still, where's the line in the sand on that issue? My client may say this is relevant, and you present time, cost, and the judge is going to say, now it's not relevant, I find that it's not. So, that's still a factual determination.
Delegate Campbell.
But you said a judge 95% of the time gets it right in your prior experience.
Not 50%, but generally, yeah, I would say so.
Okay, that being the case, if you include other abuse in this as being relevant by the court, don't you think the court would be in a position to be able to make a determination whether any of that's relevant, whether the abuse was so remote in any way that it shouldn't be considered?
Problem is, it's still what we mean by abuse. I mean, what level of conduct constitutes other things that you can look at?
The real problem they have
That's
is
the problem.
other abuse raises the risk that somebody says picks up the bar fighting theory, it picks up that he pushed somebody a long time ago, is their risk, and I get it. The thing that troubles me about the case that we heard about, Tyler's case, that's so frustrating to me, is I think that was family abuse. Because when you go to look at the section that defines family abuse, it talks about abuse about family household member. When you look at the definition of household member, it's really big. It's spouses, former spouses, grandparents, children, mothers-in-law, people you cohabitate with, any child you have, any child of the person you cohabitated with. I actually think that guy was a bastard family abuser that should have been admissible under the mental health, the other factors, and the family abuse section. And so where I totally agree with the goal of this, but where my concern is I actually think we may already have everything covered, and that just makes me nervous that when we tweak it of how a court is going to interpret a change, because when a court sees a change, they're going to think we're sending them a signal, and are they going to read the wrong signal? And I don't know.
That's our concern.
I think it's legit. Everything that Tyler, his mom, Delegate Levine, and everybody else has said is totally appropriate, and everything you said is totally appropriate. All right, did you want to testify to the bill too?
Thank you, Mr. Chair. Sushila Varghese from Virginia Poverty Law Center, and I've talked to Delegate Levine, as well as Delegate Campbell and others of you about this bill. My concerns are what you have just brought up. Other abuse is not a phrase that is used in custody and visitation matters now. And yes, we asked you to change that definition, but it's still too broad and vague. Using that other abuse there to allow judges to excuse factor number 6. And I'm concerned about unintended circumstances. And I'd be happy to work on language over the next year about this.
Okay. Okay. Delegate Fossey? Yeah. Well, Delegate Lee gets the last word.
A few things. I was never given any substitute language by any of the groups here. I would like to have seen some. There's a very, very important part about paragraph 9 that has not been mentioned.
Yes, the subdivision 6 part.
And that 6 requires parents to put a child with another parent and to actually support the child's contact relationship with the other parent. By law, even when that parent is extremely abusive, unless the abuse specifically occurs to that child, you could have a man abuse 50 kids in the church basement, and the law would require that man to have custody of the child according to 6, because the only exception to 6 is in subparagraph 9.
So what it's worth, I totally disagree with that. 6 doesn't say you have to the person with the kid. That 6 is one of the factors to consider. And 9, if you find abuse under 9, you simply don't consider the propensity factor under 6. But if you have somebody who's totally mentally unfit under 2, 6 doesn't require you to put that kid with the parent.
Well, mental condition, Mr. Chairman, obviously, and the propensity for abuse are different things.
No, what you're saying is the only way, you're saying because of 6, the only way you can not put somebody with them is if you find a violation of 9. I think that's a wrong reading of the statute. 6 doesn't say you have to put the kid with the parent except for 9. 6 is a set of factors that you don't have to consider if you find 9.
Right.
But the court could, under 1, 2, 3, 4, 5, 7, 8, or 10, still decide that the factors in 6 don't overcome it and they're not going to put the kid with them.
Mr. Chairman, the court would have to say that any parent that does not put their child with someone who is a serial abuser, 6 counts against that parent.
Just a factor. It's just one of the
It's
other
one
factors.
factor. Right, so factor 1 is the age, physical, and mental condition of the child, giving due condition of the child's changing developmental needs.
The point
That
is,
doesn't-
6 says, one of the factors is enumerated in 6, is if they take care of the kid. It's the propensity to actively support the child's conduct and relationship. 9 says, if you rape kids or beat kids or abuse kids, you don't have to take into account the fact that they support the kids.
Only certain kids.
That's right.
If you rape or abuse your own kids. If you rape or abuse other kids, the courts will say that you have to allow that raper and abuser to be with the child, or it will be counted against you.
That's not what it says.
It's one of the factors. It's one of the factors.
Yeah, it's not what it says.
It's one of the factors. So again, there's no abuse in number 1. There's no abuse in number 2, because mental condition is a separate legal concept from abuse.
Except Mr. Deal said they oftentimes use that. The history of abuse, they bring an expert to show that's evidence of mental condition. And they do use it that way, is what the testimony was. I don't do family law, so I don't know if you're right or not.
Mr.
Have you seen
Chairman,
that? We have, yeah. We would try to use abuse of the mental condition or style, something's done in these cases. Yeah, people try to do it probably. Okay, all right.
I mean, these cases are incredibly factually specific. I mean, we want the law to be broad to encapsulate as much information as we can. That's why,
I mean, the problem is somebody a long time ago should have said the court can consider whatever factors the court deems necessary, period. But then really smart legislators said, well, we need to make sure they consider this and then that and then this and then that. And so we went from the broad to the specific.
well, what we have here, by the way, what the example about pinching and so forth, that the language that I had originally in the statute was directly from the family abuse. So it sounds to me like Mr. Neal has a problem with the current law, which says that if you abuse your own child, that's a factor, because the exact factor that he had a problem with is already in the current code. And indeed, he said, in fact, that abuse doesn't necessarily mean that you're a bad dad. I think the court should have the discretion to take everything into consideration. And I think that that's actually what this committee believes. The court should have the discretion to take everything into consideration.
Well, I think the thing that we're all going to leave you agreeing on is that last statement. We all believe they should. And I think the question that will be reflected in the breakdown of the vote is, do we think they already do, or do we think they need another provision?
Well, the courts have said they don't. We know that in Mr. Russell's case, the court specifically laid out findings and said, I cannot consider this abuse. By law, and the court cited 124.3, the court said, I cannot consider abuse unless it happens to the child. That was this court's finding. And actually, it's unappealable because the code says, in fact, the court does not have to consider other abuse. So courts are finding this, and you heard Ms. Russell testify as a social worker, and I can give you several other cases that she cited, that this is a frequent problem. At the end of the day, I'm saying let a court decide. Let the court get the information. Let the court decide. But to say, as the current law does, you know, we care about family abuse here in the General Assembly, and we care about sexual abuse. But we specifically exclude abuse outside of that limited category. We don't care if you abuse other children outside of your child. You just heard Mr. Gill say, you know, I don't know that the abuse is related. He said, I don't know if a man abuses a child that's not his own child, if there's a nexus, and that's the word he used, to the own child. Well, I disagree with Mr. Gill on that. I think any man that abuses any child, it's probably not a good dad, and at least that factor should be considered by a court. In Ms. Russell's case, as you know, the court said, I'm not going to hear you. I will not take testimony. Not I'll take testimony, listen to it, and reject it as unimportant. The court said, quote, as you heard Ms. Russell say, you're trying to piggyback on that other case. And the General Assembly says you cannot do that. And that is what this court found. That is what other courts have found. At the end of the day, what is the harm of letting a court, and you heard Dahlia Campbell say, they consider a whole bunch of things. What is the harm in letting the court consider the information and trust our courts to make the right judgment, rather than say, no, we've laid out these specific factors, and giving courts a chance to say, no, I won't consider.
So again, I think everybody agrees they need to have discretion, and the question is going to be, do people think they already have it or not, versus a bad judge situation? And we did hear them and say what they think the harm is. Okay, Delegate Lubasi. All right, Delegate Lubasi moves to lay House Bill 2120 on the table. Is there a second? Is there a second? Hold on. What do you want? No, he said.
This support.
What's that? Move to support.
I didn't hear a second.
I know, Lester's asking me to hold on for a second. I'm trying to figure out where the hierarchy of a motion to support is.
I'll second.
The motion to support, you seconded.
Move to report.
Hold on. We have a motion to lay the bill on the table that has been recognized. We have a second to that motion. It's a non-debatable motion. If that motion fails, then you can make your motion too. Yeah, okay. All those in favor of laying 2120 on the table say aye. Aye. Those opposed? No. Okay, that's 1, 2, but you know? All right, that motion fails. We have a motion to recommend reporting.
Motion failed.
Yes, that motion fails. We have a motion to express our support through report. And that motion is seconded by Delegate Campbell. All right, all those in favor say aye.
Aye.
And that is your aye, or you're, raise your hand if you're an aye. I mean, no, the ayes have it, but raise your hand if you're an aye. 1, 2, 3, 4. If you're a no, raise your hand. I mean,
I'm not a Methodist, I'm a
it's 4-3 because somebody didn't vote.
I need to
All right, the motion to report succeeds on a 4-3 vote.
Okay.
Pope, Minshew, Kilgore, and Campbell. Delegate Toscano had left the room to go to the restroom. He didn't cast a vote. All right.
4-3 report.
The bill reports 4-3.
Thank you, Mr. Chairman.
Leave quickly.
I
You have, hold on a second.
43 report. I did not have, my hand's not on.
All right, that's fine.
Either way.
Thank you, Mr. Chairman.
You have another bill,
I do.
but Kilgore has.
That's a very similar bill.
Yeah, you want to hear your slap bill now?
We have a similar bill, okay? Mine's similar to his.
All right, we're going to start with.
I like his, and hopefully he likes mine.
This is House Bill 1941.
All right, 1941. All right, this is what you call an anti-SLAPP bill. This is to protect somebody who makes a comment from previous lawsuits intended to censor, intimidate, or silence them. Basically, what it is SLAPPs are strategic lawsuits against public participation. And you know, if you go on to one of these websites and you're there and you say this food was terrible, then you might get sued for saying that. Or if you go into a public, well, you're protected in a public meeting, but if you go on a website and say that Delegate Aviv, he doesn't know what he's doing when it comes to law or any of you, then you know there's a possibility that somebody could take a suit against you. And you know these lawsuits produce a chilling effect in the public square and the marketplace, and if you're a consumer, you're going online a lot of times to look and say, what do people really think about this hotel, this restaurant, and you know, you try to get some free exchange of ideals as you're going looking through there, and you get you know, you got Yelp, Angie's List, TripAdvisor. A lot of those companies provide reviews, and folks are afraid sometimes to provide honest reviews because they might get sued. And there have been some slap cases here. I think one went to where's my lawyer at? Jason Ige is here, but you know, Jason, if you can come up here, I'll call him as my first witness.
Mr. Chairman, members of the subcommittee. Yeah, there's been several Virginia cases that have actually been more or less high profile. Washington Post has reported on them. Richmond Times have. A couple of them have gone to the Virginia Supreme Court, at least on appeal, while the Virginia Supreme Court denied the appeal. The defendant, who was just a consumer writing these honest reviews, obviously had to pay for attorney's fees all the way through the appellate process and deal with those. So a couple of them were actually brought, discussed last year here in Richmond, which precipitated, I think, a couple of the anti-SLAPP legislation that you all passed last year. But that only included speech before a public body. And what we're trying to do here is expand that public speech to include written speech and also speech regarding consumer products, services, and so forth. I think the stats show that about 70% of all consumers who purchase a good service first go online and utilize some type of review, whether it's on Amazon, Yelp, or some other retailer. So this is obviously a significant issue or part of our economy now, relying on those type of reviews before making purchases. 28 states and the District of Columbia have SLAPP laws on the books, including states as diverse as Texas and California. So this is really not a partisan issue.
Including Virginia.
Including Virginia in a very narrow exception. So this is really not, it's a good point, it's really not a new policy, but all we're trying to do is take the current policy, which you again voted on last year, and expand it to include, like I said, written speech, include defamation cases directly, and also what I like to call marketplace speech or consumer speech, which is the honest reviews.
And I do understand the Supreme Court does have a issue with the.
I would expect with the priority part.
Yeah, so I think I would be happy. I would be happy with the motion that would take that out.
Yeah, so the amendment is on line 25 after false period to strike the rest of 25 and all of 26, which is Delegate Kilgore's heavy-handed attempt to mandate what our judges hear first for last.
So moved,
Right.
Chairman.
Get that out of the way.
Right. All right, we have that's been moved and seconded that we strike that language. All those in favor say aye. Those opposed. Let me ask you the other change to the existing law that you made that would apply to the existing law is the change in the attorney's fees from may to shall, which is inconsistent with what we normally do with attorney's fees. Is there something unique about these cases that we have to have shall?
I'm moving to strike it and make it nay.
Can I, go ahead. Mr. Chairman, can I offer an alternative to consider regarding attorney's fees? There's another way of doing this where it would remain shall, but the prevailing party would collect the attorney's fees. So it could work both ways.
Right.
In other words, if you
Yeah, we don't
follow
Do that.
I understand, I'm just giving an alternative to changing
Appreciate
shall
you.
back to may.
I got a motion to make it nay.
All right, is there a second on returning it to May? Second, and moved and seconded. All those in favor say aye. Aye. Those opposed. All right, so what we're left with is changing the definition, or adding a definition of matters of public concern to include health or safety, economic community well-being, economic or community well-being, I'm not sure what that means, or related to a good product or service in the marketplace, and then adding in defamation and not limiting it to an appearance before some kind of tribunal, but to include communication with third party. Is that an accurate description?
Yes.
All right, y'all know my feelings on it, so I'm just gonna sit quiet now.
I just have a couple of witnesses.
Come on up. If you're here to testify, come on up.
There's a lot.
I'd say one,
He does have a Ronald label
Members of the committee, thank you for the opportunity to appear before you. My name is Angela Hope. I am on the public policy team for Yelp. Yelp is an online platform dedicated to connecting people with great local businesses. Our users have ranked over 115 million reviews on everything from coffee shops, restaurants, to D&Bs, to doctor's offices. I think it's safe to say that people share their opinions and experiences with friends and family members in real life all the time. The internet has only amplified this type of engagement, allowing you to share your review or your experience at a restaurant, veterinary clinic, or product serve hundreds, maybe thousands, or even millions of people. And so there's actually a study from 2015 that says 70% of consumers are looking at online reviews before they make a purchase of a product or service, and that's a very significant number. Additionally, this type of direct and in real-time feedback allows added transparency into our marketplace, ensuring that businesses are responding to the needs of their consumers. Yelp has been a proponent of anti-slap legislation over the years, and this is because we want to ensure that our consumers can share their honest opinions online without fear of intimidation. Our general counsel, Aaron Sherrod, testified at the federal level last summer, and he actually shared an example from a Virginian, and I'd like to share it now. This is something that we received through Yelp's internal messaging system on why a consumer was scared and trying to pull down the review. And it's from May of 2016, and it is anonymous, and it has been edited for brevity. But it said, a dentist has threatened me with a huge lawsuit if I don't take the review down. Also, he is falsely accusing me of defamation. Everything I wrote in the review and updates are true. I have paid receipts from them for the work I originally came in for. Additionally, the reviewer actually flagged the message that the business sent him, and the message began with, the truth can be an expensive defense in a courtroom, and the burden of proof is on you to prove what you write happened. And so that in itself just shows why these lawsuits are bad and why anti-slap legislation is something that we support. There are bad actors that are out there that are using the threat or actually going through lawsuits in order to intimidate people based on what they're saying. So to further show this, I just wanted to use a number for TripAdvisor, which is a peer review site that is actually a competitor of ours, and they're also really big supporters of anti-slap legislation and have been working with us in the past to promote this type of legislation. So they estimated that in 2015, 2,500 reviewers pulled reviews based on threats of lawsuits from different businesses, right? And so this number is probably really low because there's a lot of people that just don't go through the process of actually saying why they're pulling reviews, they just pull it. So just in conclusion, Mr. Chairman, Yelp is dedicated to ensuring our users have the ability to share their honest experiences online without fear of intimidation. And that includes supporting this piece of legislation. Just one lawsuit or threat has the power to stifle the speech of many, which harms our growing online economy and just businesses everywhere.
Hey, Mr. Chairman, who's the best person to ask technical questions about the words? Is that Jason? Well, we don't need to get too now. I'll say my questions to whoever the right person is.
Okay.
Is there someone, other people want to testify in the bill? Come on.
Mr. Chairman, I also